My name is Joe Reynolds, and I'm the attorney assigned by the Texas Water Development Board to conduct these hearings. Before we begin, I'd like to make a few standard announcements. The first of which is that if you have one of those little machines that you carry in your pockets that goes off at an appropriate time, please set it on none, if right, or off, or whatever. Appreciate that. If you are one of the presenters, I would make sure that the court reporter has all of your information, including a sense of how you intend to make your presentation. Under the board's rules, today's testimony will be limited to the petitioner and the respondent groundwater district. There will be no time allotted for public comment. The rules provide, however, that other testimony may be submitted to the Water Development Board during a 10 business day period following today's hearing. That means that anyone who wishes to submit additional testimony to us has until the end of business on Wednesday, March the 14th to submit written comments to the board. That needs to be accompanied by an affidavit to which you swear that you identify yourself and note that the comments that you are making in there are true and accurate to the best of your ability, and describe who you are and what your position is in relation to this petition. The samples of those affidavits are over on the table. It also contains not only the mailing address, but also my email address. So if you wish to submit those comments by email, you may do so, and that will come directly to me, and they will get into the record that way. With that said, I will now call to order this hearing on appeal of desired future conditions for the Sparta, Queen City, Corrizo-Wilcox, Calvert Bluff, Simsboro, and Hooper aquifers that were approved by the Groundwater Management Area 12. A petition was submitted by L.L.P. under Texas Water Code Section 36.108, which states that a person with a legally defined interest in the groundwater management area, a district in or adjacent to the groundwater management area, or a regional water planning group for a region in the groundwater management area may file a petition with the Texas Water Development Board appealing the approval of the desired future condition that the GMA has established under the statute. That petition must provide evidence that the districts did not establish a reasonable desired future condition for the groundwater resources in the groundwater management area. 31 Texas Administrative Code Section 356.44 requires that at least one hearing on the petition to take testimony from the petitioner and the respondents be held at a central location in the groundwater management area. Notice of this hearing was published in the Texas Register on February 24th, pursuant to the rules of the Texas Water Development Board, and was provided to the petitioner and the district on February 1st, 2011. This hearing is in fulfillment of these statutory and regulatory requirements. And with that said, I'm going to turn it over now to the petitioner, L.L.P., and to make their presentation. Nathan, it's all yours.
Mr. Reynolds and the district in GMA 12, my name is Stacy Reese, and I'm a lawyer with the law firm of McGinnis, Lockridge & Kilgore in Austin, Texas. And I'm the law firm representing petitioner L.L.P., who is bringing this appeal. We also represent L.L.P. in connection with obtaining permits from the Lost Pines Groundwater Conservation District. I'll be giving introductory remarks, and then I will turn the presentation over to Mr. Thornhill of the Thornhill Group who is NDOT's hydrogeologist in this matter. And a representative from NDOT is here today, Mr. Francis Zimmer, although he will not be providing any remarks today. We would like to reserve 15 minutes of our allotted time for rebuttal in response to respondents' testimony. NDOT has provided notice and timely filed its appeal pursuant to Chapter 36 of the Texas Water Code and Chapter 256 of the Texas Administrative Code. NDOT provided the Water Development Board and the districts in GMA 12 a file-marked copy of its petition, along with a hard copy of all evidence previously submitted with this petition at this proceeding today. And NDOT's petition and all evidence submitted with this petition are incorporated into this testimony as if set out in full. As required by law in order to bring this petition, NDOT has a legally defined interest in groundwater in GMA 12. NDOT leases groundwater rights covering over 17,000 acres of land in Lee and Bastrop counties, both of which are in Lost Pines Groundwater Conservation District and thus GMA 12. In 2007, NDOT filed 14 permit applications with Lost Pines Groundwater District seeking permits for 14 wells that would be located on land leased in Lee and Bastrop counties. If granted, the 14 permits would grant NDOT the right to withdraw up to 56,000 acre-feet per year of groundwater. In 2008, NDOT purchased the real property upon which well number 10 is located and subsequently drilled a test well on well number 10 after receiving Lost Pines approval. The Thornhill Group did extensive testing and conducted an unprecedented hydrological testing and published a report on its findings, which has been submitted into evidence in this proceeding as Exhibit 7. GMA 12 failed to consider these findings when it established the DFCs for the Simsboro Aquifer. NDOT seeks two findings from this board: that the DFCs set by GMA 12 are not reasonable, and a recommendation that the districts in GMA 12 revise their DFCs. This proceeding should be informed by the Texas Supreme Court's recent opinion in Edwards Aquifer Authority v. Day, in which the Supreme Court held that land ownership includes an interest in groundwater in place that cannot be taken for public use without adequate compensation pursuant to Article 1, Section 17A of the Texas Constitution. The Supreme Court reasoned that any regulation of a landowner's constitutionally protected interest in groundwater must consider relevant factors and be justified in order to protect the resource. The DFCs set by GMA 12 regulate the landowner's constitutionally protected interest in groundwater, and the regulations the DFCs set by GMA 12 are not justified, given that GMA 12's DFCs are completely arbitrary. The standard for establishing reasonableness is governed by a Texas Water Development Board rule stating that the Water Development Board shall consider the following 7 criteria for determining whether a desired future condition is reasonable. 1. The DFCs are physically possible, consideration given groundwater use. 2. The socioeconomic impacts reasonably expected to occur. 3. The environmental impacts. 4. The state's policy and legislative directives. 5. The impact on private property rights. 6. The reasonable and prudent development of the state's groundwater resources and any other relevant information to the specific desired future conditions. GMA 12 has presented no evidence that it considered these necessary factors and thus can't establish that its DFCs are reasonable. Further, GMA 12 has not presented any evidence that the DFCs it said were established to protect the resource as required under Edwards Aquifer Authority v. Day, the recent Texas Supreme Court opinion. Rather, the DFCs are arbitrary numbers resulting from an innately flawed process. For example, with regard to Lost Pines' acceptable drawdown for the Simsboro Aquifer, Lost Pines indicated in March 2010 that it would set the DFC for the Simsboro at 285 feet, which would have allowed for additional production not currently permitted. But then later, Lost Pines submitted a DSC of 237 feet in August 2010 that does not allow for additional production not currently permitted. On what basis was the decision made to reduce the drawdown by 48 feet, and what is actually protected by reducing the drawdown by 48 feet? This DSC is arbitrary, and the decision to set the DSC at 237 feet had nothing to do with protecting the resource, because the evidence submitted by NDOT shows that the Simsboro resource is prolific. The arbitrariness of the number can only be explained as a desire to prevent additional production, and the same can be said for all of the DSCs set by GMA 12. Although the burden is on GMA 12 to show that it considered the 7 factors that I mentioned, and that its DSCs are thus reasonable, and it has not shown any evidence in this regard, I would like to discuss a couple of the factors which per se deem the DSCs unreasonable. I would like to discuss the impact on private property rights and the reasonable and prudent development of the state's groundwater resources. With regard to the impact on private property rights factor, the desired future condition process is decided entirely by groundwater district representatives, and there is no stakeholder input in establishing these DSCs. The only avenue for a landowner to evaluate the DSCs once they are established and file a petition within 1 year if they are unreasonable, which is the process that we're undertaking today. Consequently, the DSC is an example of local control gone rogue. The local groundwater districts in GMA 12 have ignored real scientific evidence, such as that provided by NDOT about how prolific the aquifers are, and instead they have reverse engineered DSCs that prevent additional production. When I say reverse engineer, I mean many districts are deciding how much water should be authorized for production by having the Water Development Board run their groundwater availability models and obtaining managed available groundwater results to determine if the DSCs meet their goals. If the selected DSCs result in too high a managed available groundwater number, districts are setting more conservative desired future conditions, which result in the calculation of less managed available groundwater. In short, the drawdown levels are extrapolated backwards from current demand rather than scientifically from an analysis of the aquifer's actual condition. Yet isn't the purpose to determine the desired future conditions of the aquifer itself, not the desired future conditions of a projected demand? Further, landowners' rights in GMA 12 are being trampled on in the DSC planning process. NDOT represents many landowners in Lee and Bastrop County, over 17,000 acres, which is not an insignificant amount. And NDOT represents these landowners whose ability and right to produce groundwater is being denied because of the reverse engineered method used to establish the DSC. NDOT has invested millions of dollars in an unprecedented Simsboro groundwater project, the results of which were completely ignored by GMA 12. And NDOT did this with the legitimate expectation of being able to exercise its right and the rights of the landowners it represents to produce groundwater.